Hello and welcome to the 2021 Virtual Education Law Symposium. I am Dr. Mary Beth Boyer and I will be talking with you today about child custody conundrums. During our presentation, as an overview, we will be talking about some common terminologies regarding child custody. We will also look at frequently asked questions and answers, and then we'll do a review of FERPA, which is the Family Educational Rights and Privacy Act. But before we begin, let's look at what we know and what we may not know. So just 5 simple statements, and go ahead and jot down either on paper or if you can remember whether or not you think these statements are true or false. The first one, all educational institutions are subject to requirements of the Family Educational Rights and Privacy Act, also known as FERPA. Statement number 2, FERPA prevents disclosure of information from a student's education record, but does not prevent disclosure of directory information. Statement number 3, a school must provide the non-custodial parent the same general notices it provides the custodial parent. Statement number 4, a non-custodial parent has the right to be informed of and attend teacher conferences. And number 5, a school can be sued for not notifying a divorced parent of significant school events. So take just a couple seconds and write those down. Okay, so let's move on and let's look at some common terminology that we need to be aware of in our schools. And we're going to look at terminology as it relates to custody. So the 2 main terms we need to be familiar with are legal custody and physical custody. Legal custody basically determines who makes important decisions for the child, and physical custody determines who the child lives with. Oops, let's go back there. So let's look at legal custody first. Legal custody is responsibility for making major decisions affecting a child's welfare. Courts often award parents shared legal custody so that even parents who are not a couple are expected to communicate and cooperate with each other to jointly make decisions in the child's best interest. When there is evidence that the parents cannot adequately communicate and cooperate regarding a child, the court may award one parent sole legal custody, meaning that parent has exclusive authority to make major decisions regarding the child's welfare. Keep in mind the fact that a parent has been awarded sole legal custody does not, however, eliminate all of the other parent's parental rights. The parent who does not have legal custody still has rights of access to their child's educational records, just not decisions-making authority. So keep that in mind when we discuss FERPA and release of educational records. Let's move on to physical custody. Physical custody is entitlement to spend time with the child. Awards of physical custody should assure that the child has frequent and continuing contact with each parent to the maximum extent possible. It is common that parents share physical custody. Orders regarding physical custody often establish a custody schedule specifying the time the child can spend with each parent, unless the parents agree otherwise. Although the law favors a child spending time with each parent, there can be court orders for a child to spend more time with one parent and less time with another. And when we look at physical custody, you may come across other defining terms such as primary custody, which means the court has ordered a child spend more time with one parent than with the other. Or you might come across 50-50 custody, which refers to physical custody order that calls for the child to spend equal amounts of time with each parent, such as alternating weeks or weekends. Guardianship is another term we need to be aware of, and guardianship refers to a person who is appointed to make legal decisions for somebody else. A guardian is appointed to make these decisions for a person who is unable to make those decisions on their own. Guardianship is often over a minor child or an individual who's become incapacitated, either through age or disability. Minor children may have guardians when their parents are deceased or are incapacitated. A court can appoint a guardian for an unmarried minor if all parental rights of custody have been terminated or suspended by circumstances or previous court order. Whenever a school is informed that there is a guardianship, please be aware that the school should request that the person who claims to be a guardian provide a certified copy of the order establishing that guardianship. We also need to be cognizant of any restraining or protective orders that are in place. And a restraining or protective order is an order that helps protect a person from violence, stalking, harassment, or any type of violence. Again, individuals who have been victims of this type of harassment can petition a court to issue a protective order, also known as a restraining order, which limits the perpetrator from contacting or being around them. The person who seeks and is protected by the order is called the petitioner, and that is the person who we want to be able to protect. The person whose rights would be limited by the order is called the respondent. Because the protective orders are tailored to a specific situation, it isn't sufficient to just know that that order is in place. It is very important to have a copy of that written order and to read the terms of each order to determine the duration of the order and what conduct that particular order prohibits. It's also extremely important to know if that order has been dissolved or modified. Whenever a parent tells the school that there is a restraining order, please ask for a certified copy of that written order and ask whether there are any other orders, such as any order dissolving, modifying, or extending that restraining order. Know that these protective and restraining orders do have specific durations. Once a protective order expires, it is dissolved or suspended. That order has no further legal effect and we have to ignore it. However, if we have any concerns about the safety or welfare of a student who has been previously protected by an order, those current concerns can be relayed as appropriate to the Office of Children's Services or law enforcement, depending on the nature of concern, depending on your state and access as to who you need to call when you do have a concern of any violence or threat against that child. Let's look at some typical questions that we have when it comes to custody. So let's take a look at one that often comes up. What documents should we obtain when a parent reports there is a custody issue or a case? So the school should ask the parent for a certified copy of the custody order or decree and of any subsequent orders or modifications. So when we do get this order, who should we share this document with? Is it protected information? Quite often we get questions as whether or not only a principal or head of school or administration should have a copy or knowledge of that. Well, the terms of the order need to be shared with staff beyond the front office might depend on what the order says. It may not be necessary to distribute a fairly routine order for shared legal and physical custody that just sets out things like a schedule for which nights a student stays with at which house and so on. However, if there is a custody order that granted sole legal custody or some protective order which curtailed the parent's rights to have contact with the child or cut off access to educational records, then it is appropriate to make sure that the teacher or others who might commonly interface with the family know that the order is out there so that they don't unknowingly facilitate violations of that order. When there is a disagreement on the custody order, do we always rely upon the order the school has, or do we take the word of the parent? So what we need to do in this situation is you have to rely on the certified copy of the court orders that you have been provided with. If a parent contends that the order on file with the school has been modified or suspended, then the school administration needs to ask that parent to provide a certified copy of any more or recent relevant orders. So be sure if a parent is contesting that the the order you have on file is incorrect, that parent provides the most current certified copy. We can't just take the word of the parent. We need to protect the child and the school and any litigation that could come about. Another question we often get is, who has the right to enroll a student when there is shared custody? So when a parent is enrolling a child in school, we should operate under the assumption that they have the right to enroll the student unless notified otherwise. When our schools have been advised that enrollment is an issue, we need to look at the terms of the certified custody order provided by the parents. A parent who's been granted sole or exclusive legal custody does have authority to make the decisions alone. When a court order has shared legal custody, um, the parents are expected to be able to communicate and cooperate to make decisions together in the best interest of the child. If the parents cannot do so, then a parent should move the court to modify the order that requires shared legal custody. The school, keep this in mind, the school should not mediate those disputes or prefer one parent over the other. I'm going to read that part again because this does come up quite often. The school, or we cannot, as schools or administrators, mediate those disputes or prefer one parent over the other. What we need to do is get a certified copy of those legal orders. Regarding custody, the basic standard courts apply to decide almost all cases involving parent disputes over child rearing and decisions is the best interest of the child. And you have heard me mention that in some of the Q&A that we had earlier, and some of the definitions of custody. And those do come about because we want the best interest of the child to be taken into consideration. Typically, the parent with physical custody gets to make the decisions, but again, we need to look at those certified court decrees to assure that that is the case. Custody decisions are open to renegotiation and reversal. And also, judges can depart from the norm if they conclude an unusual custody determination is, again, in the best interest of the child. So understanding what some of the terminology of custody is and what it looks like, how does that apply when we discuss the FERPA and educational records, and which parent has access to these types of records? So we're going to move on and we're going to discuss, we're going to skip over a question and answers. We just did that. We're going to move into FERPA so we understand what exactly that means. And again, it's the Family Educational Rights and Privacy Act, also known as the Buckley Amendment from 1975. And it provides guidelines to help govern access to academic records and progress. So we're going to watch a short video together. This is actually from the U.S. Department of Ed, so it's a concise overview, but it's imperative that we understand what FERPA is and how it applies to our schools.
The Family Educational Rights and Privacy Act, or FERPA, is a federal law which applies to educational institutions and agencies, such as schools, school districts, colleges, and universities, to which funds have been available under any program administered by the Secretary of Education. The purpose of FERPA is to protect the privacy of parents and students with regard to education records under Section 444 of the General Education Provisions Act as amended. Wow, it's easy to get confused with all that legal language. Let's try that again in plain English. The truth is, data about us is everywhere. It's collected when we shop, take a vacation, look at a web page, or send an email. You see, FERPA is a federal law that applies to most schools, colleges, and universities. It's meant to protect all that identifiable information about students in records that are kept by schools, and it provides the right for you to access that information, to seek to correct it, and generally to consent to its disclosure. Let's take a closer look at what that means. Today is Patrick's first day of kindergarten. As Patrick moves through the education system, his schools accumulate data, such as his grades, learning disabilities, or special needs information, and disciplinary information. As Patrick takes tests to see how he's progressing, his scores are protected by FERPA. FERPA requires schools and state and local educational agencies to keep the information that came from Patrick's records private and get his parents' written consent before sharing it with anyone else. There are some exceptions, but the general rule is Patrick's records are confidential. Students don't attend school anonymously, so schools routinely share some basic information about students, called directory information. If a school is going to share directory information, it must notify parents and students who are 18 or over or who attend post-secondary institutions. For example, Patrick's school yearbook contains his name, grade level, and photograph. That's okay because his school designated these items as directory information and published its policy on its website, and Patrick's parents haven't opted out. FERPA also requires schools provide Patrick's parents the ability to review his records to make sure they are accurate. Patrick's applying to college. He and his parents review his high school transcript and discover the school has gotten Patrick confused with another student who has lower grades. This isn't good. FERPA not only gives his parents the right to see the records, but also to request that the school correct mistakes. If Patrick's parents and the school disagree on the accuracy of the info, FERPA gives Patrick's parents the right to request a hearing. Colleges and universities are also required to protect student information under FERPA, but the rules change a bit. Meet Lisa, a high school graduate who is headed off to college. Hooray! While Lisa was in elementary, middle, and high school and under the age of 18, FERPA allowed her parents access to her education records. Now, Lisa is entering college, and her FERPA rights transfer from her parents to her. Her parents wonder, but wait a minute, I'm paying the bills here, and now I can't see how she's doing academically? Since Lisa's parents claim her as a dependent on their federal tax return, her parents can still see her education records if Lisa's college chooses to release them. FERPA doesn't require schools to release records, it only allows this. You may be wondering, how do I find out more about how FERPA affects me or my child? To start, look for your school or school district's FERPA policy on its website, or ask your principal or school administrative staff about your rights under FERPA. Visit the Department of Education's Family Policy Compliance Office website for answers to frequently asked questions on privacy, training, and guidance for parents and students on FERPA rights and protections.
Okay, so hopefully I didn't scare you away with the lightning speed beginning of that video. I meant to actually give you a heads up that our speaker in the video did slow down when she made her point. What I want to touch on this is from the U.S. Department of Ed. And there are some pieces of the video I want to go over to make sure we understand on this. So let me go back. We don't need to see it again. So when we talk about FERPA, the institutions that are covered are any public or private agency or institution, which is the recipient of funds under any applicable program. So how does this apply to our Catholic schools? If we receive any funds or assistance from the government, then FERPA does apply. The records that are excuse me, the records that are covered include, I apologize for that coughing interruption. I'll go back to covered institutions again. Any public or private school that receives federal funds has to adhere to a FERPA. And the records that are covered include any records, files, or documents and other materials which contain information directly related to a student and are maintained by an educational agency or institution or by a person acting for such an agency or institution. And that's our Catholic schools is what we're referring to there. And if you want to take a look at more in depth, I have the link below to the video and to the federal site. And I'll also have that at the end of our presentation together. So again, FERPA is designed to protect the privacy of both parents and students. The law requires a school to provide a parent access to the records that are directly related to the student. Also provide a parent an opportunity to seek correction of those records if they think that they are incorrect or have misleading information. And in certain situations, obtain the written permission of a parent before disclosing information contained in the student's education record. So you'll see here on a chart, hopefully you can read it from your end. It's a nice and concise. You can find this chart on the CDC website. And there's information, if you look in the first column, about FERPA. Again, it's a federal law enacted to protect student privacy, or rather the privacy of student records. It gives parents and students access to those records. And this is why it's important to understand the custody piece as to which parent has the legal right to those, to those records. And if you look at the second column, this is where it applies to us as private institutions. Any public or private school, including elementary, secondary, or post-secondary. And the law applies if we receive funds under applicable program of the U.S. Department of Ed. So think Title I, Title II funds. And you can see in our second column what records, what student records are protected and where those records can be disclosed. So again, if you want to see this chart, go ahead. You can see it on the CDC website. So some key points we want to remember is if there's no custody order, verified biological parents do have rights, equal rights to the child. And again, we've mentioned and made it hopefully clear that as schools, we can request, and we should request certified court copies or certified copies of any custody orders. Remember, school personnel have no legal obligation to provide letters of support or recommendation for parents involved in custody battles. For parents with joint legal and physical custody who split time during the school week, schools should have each parent complete an emergency card. So this is a recommendation so that you do have information for both parents on file at school. The last bullet on our slide here, the school's not party to custody order. The school is not a judge and can't create or imply parental rights when it comes to these situations. Follow the most recent custody order that parents have provided to the school. So let's take a look at our 5 statements that we started our time together with. And let's see if you've changed your answers on any of these 5 statements. We have the statements here, and then we're going to go over them to make sure we understand the relevance of them. So statement number 1, all educational institutions are subject to requirements of the Family Education Rights and Privacy Act, or FERPA, which we just discussed. So this is false, as we had mentioned in the prior screen, and you saw on the chart from the CDC. Only educational institutions receiving federal assistance administered by the Secretary of Education or the U.S. Department of Ed are subject to FERPA. Statement number 2, FERPA prevents disclosure of information from a student's education record, but doesn't prevent disclosure of the directory information. This is true, and the defining character in this is the difference between an education record and the directory information. FERPA allows schools to disclose this information without consent as long as they provide public notice to families that explains what types of information the school has designated as directory information. And I suggest that you include that information in your handbooks so that it's very clear as to what is meant by directory information. Statement number 3, a school must provide the non-custodial parent the same general notices it provides the custodial parent. And this, the terminology is copied directly from the National Center for Educational Statistics. And this is actually false. And this is the reason being is that general notices such as menus, PTA information, announcements of teacher conferences, and school pictures or any similar information are not educational record as defined by FERPA. Therefore, the schools are not legally required to provide them. Statement number 4, a non-custodial parent has the right to be informed of and attend teacher conferences. This is false, but let's look to see why it's false. FERPA does not address conferences for the purpose of discussing student performances. Thus, a school has no obligation under the law to arrange a conference to accommodate the non-custodial parent. However, and this is the important part in this statement, if the records of the conference are maintained, then the non-custodial parent does have a right to see those records. So again, keep that in mind. If there's any record of the conference that's maintained, the non-custodial parent does have a right to see those records. The fifth statement I included because it's an overlap of custody concerns as well as contract law, which governs our Catholic schools. So the fifth statement, a school can be sued for not notifying a divorced parent of significant school events. And this is from Hawkins v. Walsh Jesuit School, in which it was true. An Ohio appeals court decided spoken promises from private school principals can become part of a school's contract with the parent, so it allowed the father's breach of contract suit to go forward. And again, this is an overlap of custody and contract. And in this particular case, a divorced father had alleged principals broke a promise to notify him of his son's significant school events, thereby depriving him of once-in-a-lifetime events. The boy lived with his mother, but both parents were legally entitled to see his school records and attend school events. The father missed his son's sophomore interview because office staff wouldn't tell him when it was scheduled, and the vice principal they referred him to didn't get back to him. The school repeated the interview so the father could attend. The father said the principal and vice principal apologized and assured him they'd put his contact information in his son's school file with a note saying he was to receive notice of all events and activities involving his son. But the school didn't notify the father before his son received a scholarship in front of the whole student body or was inducted into the National Honor Society. The father sued the school for breach of contract. The trial court dismissed his case, but an appeals court reversed it. So keep in mind, to be binding, a contract has to be supported by consideration. The father claimed the principal's promise to notify him of his son's special events was part of the consideration he received in exchange for enrolling his son, so it became a term of his contract with the school. The appeals court found that the father's complaint validly stated each element needed to allege a breach of contract claim, so held his suit could go forward. I conclude with this case because it circles back to the earlier suggestion to have emergency contact information or contact cards on both parents, to be cognizant of any custody concerns, and just as a caution, to be aware of what we say and what can be construed as binding or a binding contract, since we are governed by contracts in our Catholic schools. So as a takeaway, the last key point that I want to mention is that even if a school is not subject to FERPA, school officials should consider whether adherence, if not to the letter, then at least to the spirit of the law as spelled out in FERPA, serves the best interest of our schools and our communities. As we end this presentation, I'd like to conclude with a prayer. As we are all serving Christ in our Catholic schools, let's take a moment. Look upon us, O Lord, and grant us the grace of your Holy Spirit. Where there is weakness, give us strength. Where there is disagreement, give us tolerance. Where there is misunderstanding, give us patience. Where there is hurt, give us the courage to forgive and the grace to accept forgiveness. Be present in our schools, here and in all places. Bless our work and everything that is undertaken by our Christian sisters and brothers for the furtherance of your kingdom of unity and love, peace and justice. We ask this in the name of the Father, Son, and Holy Spirit. Amen. Bless you in your endeavors and all you do for our Catholic schools.